Welcome to Behind the Built Environment, the BESA podcast. I'm David Frise, your host, and we're doing one of those interim podcasts today where we're talking about a specific topic, and we're very privileged to have with us Kizzy Augustin. Kizzy is a partner at Mishcon de Reya in the firm's white-collar crime and investigations team, where she leads on health and safety, fire and environmental matters. Kizzy is a solicitor advocate with higher rights of audience, meaning she can not only advise organisations, but also personally represent them in court, including the higher courts. And that's in relation to particularly serious health and safety, fire and corporate manslaughter cases. She also supports clients with compliance and governance and incident response. Welcome, Kizzy.
Thank you, David. Lovely to be here.
It's very good to have you here. We're going to be talking about competence today. Competence and maybe a bit of gaslighting that's been taking place in the industry, but around that. And first question is always the same, and that is, did the career choose you or did you choose the career? How did you end up working for Mishcon de Reya?
Oh, gosh. Well, in very, very short sentences, I think the career chose me. And I only say that because I started off as a criminal litigation lawyer. And it was by chance that during that time, I was able to work on the Hatfield rail crash. And we represented one of the directors. And during that time, I realized that actually this is the sort of work that I wanted to do. It was health and safety, it was manslaughter, it was criminal in nature, and combined all the things that I really loved. So I started looking for a job doing that. And gosh, 20 odd years later, here I am at Mishcon setting up my own practice, specializing in health and safety and other criminal regulatory issues for companies and senior individuals. So I think the career chose me.
And I'm kind of assuming that the business is booming at the moment. There's plenty to discuss along with.
It's pretty busy. If I said to you that I'm having sort of 4 hours, 5 hours sleep a night this week, maybe gives you an indication of how busy it is at the moment.
Well, okay. So as with the other formats, we're going to start with 5 quick-fire questions. Sounds easy. Everybody finds this difficult. So we'll pick off this. Yes, no, please.
Okay.
So, under the Building Safety Act regime, is a certificate on its own ever enough to evidence competence?
No.
Do you think the industry has a competence snake oil problem right now?
Yes. Maybe. Yes.
Yes. Don't qualify it. Is it possible to be legally competent but still unsafe in practice because culture and supervision are weak?
Yes, and I'm hoping to qualify that during our discussion.
Okay. Are clients and procurement teams inadvertently rewarding the loudest voices rather than the best evidence?
Ooh. I'd like to say no. I'd like to say no. I think there's a real possibility of yes. God, these are quite difficult, David.
Indeed. Should we challenge people who claim only my course qualifies you as potentially misleading?
Absolutely.
Great. Okay. So let's start right from the very, very beginning, shall we? Because I think we need to define something around competence. So when the law and guidance talk about competence as skills, knowledge, experience, and behaviours, SKEB, what does that mean in plain English for duty holders and the wider supply chain?
So competence, I mean, one of the things that I think a lot of clients seem to stress on is competence is being this new concept. Yes, it's got legal consequences to it now, courtesy of the Building Safety Act, but at least the first 3 elements were things that we were fairly familiar with. So in terms of skills, we knew that was what you can actually do. So it's not what necessarily you've been trained to do. It's not what you once did, but it's how you demonstrably do it now. So in the context of your current role. So if you have an engineer who was qualified 20 years ago and hasn't really looked at fire engineering since then, they're not going to be skilled in present day. So it's what you can actually do now. Knowledge, I think, is fairly straightforward in terms of an understanding of the technical or relevant technical standards, the frameworks within it sits, and the why behind many decisions. So, for a designer who is working on a higher risk building, for example, it means understanding gateway processes, the golden thread, the safety cases, and how their design decisions affect fire and structural safety. So it's not generic design knowledge, it's specific knowledge for the work that you do. Experience, again, I think if you give it a common sense approach, you're looking at the track record and how you've applied the skill and the knowledge. So in a real world situation, I'd say something comparable is the key word. So experience on low rise residential doesn't mean that you automatically can transfer that to a higher risk building. It requires an honest assessment of the gap between the two types of buildings, and you need experience for that. The new bit is behaviours or culture. And that's, I think, the element that most people are still struggling with. It's probably the most relevant to the cases that we've seen to this day, including Grenfell. It wasn't just about technical failure; it was about a failure of professional behaviour and culture. So a fear of speaking up, not questioning decisions, not escalating concerns, and refusing to, well, you should be refusing to cut corners under commercial pressure. So the Act really does embed expectations in relation to duty holder roles, if for exactly that reason, so we don't have a similar incident. And I think for the supply chain, all of those elements means that no one can hide behind the suggestion, I was just following instructions. You have to demonstrate all of those skills. Doesn't matter who you are, but whether you're a principal contractor or a designer or a subcontractor, you've got to exercise that professional judgment in respect of skills, knowledge, experience, and your behaviours.
And I'm assuming that you need those. You can't have a blanket to get on site. You get a qualification, say in air conditioning, you come on to do pipe fitting. There's not an equivalence there. You need the appropriate one.
No, I think that there has to be specificity. Film, I can never say it. Specificity in respect of competence. So, and you also need to evidence that in relation to the specific job. So somebody could come forward to you with a CV and say, this is what I have done. And then someone else can say, I've got a certificate and this proves that I can do it. But actually what it proves is on the day that they took the assessment, they were able to meet the criteria. Neither on its own probably is sufficient. In fact, you need both to enable you to assess whether or not someone is competent. And it's got to be project specific competence. What you want to see is evidence of comparable work, whether that's kind of the specifications, the drawings, reports. You want to make sure that that individual that has been appointed for the very reason that they are competent to do that role is able to talk you through how they've made those decisions. They can demonstrate and evidence their understanding of regulatory and safety implications. So that isn't something that can be just automatically transferable. It's something that is very specific to the job at hand.
You've very successfully answered the question that I was going to ask next, so I will move on. How should firms distinguish between competence for say general building work and for higher risk buildings without really turning it into a massive tick box exercise?
Well, I think the starting point has to be this getting away from this concept of generic competence. As I said before, competence is role specific, it's project specific, and it's context specific. So I think what the Building Safety Act does well, I mean, there are lots of criticisms of the Act, but what it does well is making it explicit for higher risk buildings. However, I think the competency principle applies throughout. I mean, it's the sort of thing that we should be looking at. We've always been looking at competence in construction. And in fact, the construction industry is heralded as spearheading the importance of competence, and they have been for years. I think looking at the difference between general building work or non-high risk building work, you look first to the higher risk building, and I think look at the criteria. The risk profile for higher risk buildings is very different from those that are not higher risk buildings. There's much more complex interactions with fire safety, structural safety, building systems, building regulations, and a much more complex regulatory framework that has the checkpoints, i.e., the gateways. And during those periods, competence has to be demonstrated at each and every point. So you do have to define roles, you do have to be project specific. You know, you can't just colloquially talk about a structural engineer. You might have to say structural engineer with responsibility for fire resistance in a high risk building. So I think you've just got to be a bit more granular in terms of the detail attached to competency. To avoid the tick box or the tick box approach, I would recommend to all of my clients, and I have done, that they shift from this compliance mindset to a risk management mindset. You know, the question probably is, if the person that you appointed made an error in their role, what's the worst case consequence for residents? Now, that will force a client who has to take ownership of decisions that they've made to appoint to look at proportionality, look at assessment, rather than form filling. Like, this is a compliance exercise and we've just got to make sure that we do this because the BSR says we have to. And I think organizations really do need to start thinking in that proactive, preventative risk management way. It means they've got to start documenting rationale and decisions, not just their end conclusions. So BSR has been very explicit about that. The interactions that we've had with the regulator have demonstrated that they demand ongoing competence management, not just a one-time appointment check that you've ticked the box and handed it in on time. So that means regular reassessment, especially when scope or personnel changes.
And if we moved on to the PAS and the frameworks, so 8671, 8672, and other frameworks that get referenced a lot, how should the industry use them properly? And what are the common misuses and misunderstandings that you're seeing?
I remember personally getting quite excited when we saw the PAS documents. And I think many others were quite excited because they were fairly robust documents, quite lengthy documents that seemed to draw people in the direction of a reference point on how they could meet competency criteria. So with 8671, you've got the kind of individual designer competence for building safety. 8672, you've got contractor competence. They were tools, and they still are tools, to support a structured assessment process. They can't be a substitute for an assessment. And I think the most common misuse that I have certainly seen is to treat the PAS documents as certification or proof of certification or frameworks, as if you achieved alignment with the PAS documents, it means you're competent automatically. They aren't certification schemes. They are a really good way of providing a structured way of thinking about what competence looks like for a particular role. And I think they give a really good guide on how to evidence gather during the process. But the assessment itself, it still requires professional judgment. It still means that you've got to look at whether the evidence that's provided is sufficient in the specific context. Another misuse is about selective application of the PAS documents. So, and I think I'm guilty of looking at the documents in this way as well. Organizations sometimes pick parts of the framework that are easy to evidence and they quietly ignore the behavioural stuff because that's hard. It's not tangible. Nobody really knew, and probably still doesn't know, what is the best way of evidencing good behaviours or good cultures, because it's hard to demonstrate. And that's problematic because it's the behavioural dimensions that give us this ability to escalate concerns. It questions professional integrity, particularly if you want to refuse unsafe instructions. I think those sorts of things are really important when we're looking at competence. And being selective doesn't really work with that. In fact, it's probably worse than not adhering to the PAS document at all. And I think the third misunderstanding is treating the PAS documents as the only point of reference, because they're not. You've got competence frameworks that have been introduced already by other, professional bodies, RICS, REBA, etc. They are also legitimate, whatever you think of them. And in some cases, they're more granular for specific disciplines. They point you towards specific things to do for a particular role. I think what matters for organizations is that they use a structured, documented process, and they can justify and explain their reasoning. And using the PAS documents as a governance framework, particularly for organizational capability as well as individual, and using the other professional body frameworks and documenting how those frameworks have been applied to specific appointments is the best evidence trail that you can have.
If we can take it to specifically specialist contractors now, a typical BESA member, can you talk about the difference between individual competence and organizational competence and capability, and why those two things are different and why they matter?
So this is me sort of looking at it from, I guess, a legal standpoint, but also giving the benefit of my experience from what I've heard on the ground, certainly from those in the construction industry. I think it's probably one of the most important distinctions in the Act, and it's one that organizations are still confusing and conflating. Not intentionally, but it's just because they are difficult concepts to get to grips with. Individual competence is about whether a specific person can perform a specific function to the relevant standard. It's personal, it's role specific, it's got to be verified through evidence of the person's skills, knowledge, experience, and behaviors. So no amount of organizational competence on behalf of the company is going to compensate for an individual's incompetency. So it's very personal, it's very specific. Organizational capability or competence is much more about whether the firm as a whole has the systems, the culture, the governance, the framework, and resources to deliver building safety consistently. So it's not just on a really good day with the greatest of people. It's about them being a reliable organization and providing competency across projects over time. So good evidence, I think, to demonstrate individual competence would be the records that, that I mentioned before. So having things like good assessments, your certifications, evidence been reviewed, peer reviews, etc., rationales for decision making, and ongoing performance reviews, that assesses competence in real time. And then on the flip side, good evidence for organizational capability is a bit more systemic. So it would be documented governance structures that shows you who is accountable for making decisions, how escalation works, supervision, who has oversight over checking what the firm is doing, who has oversight over the individuals and making sure they're performing in the right way, quality assurance processes. How do you learn lessons from things like near misses? All of those things are embedded into an organization's practice. And that is something that should really filter down into supply chain control processes as well. I think the critical point between the two is that organizational capability cannot substitute for individual, but individual competence without organizational capability doesn't work either. You kind of need both.
Yeah. So at the end of the Grenfell inquiry, and actually during the Grenfell inquiry, there were a lot of calls for return of the clerk of works. And what we need is more clerks of works. And there were two problems with that. One is buildings are far more complex than they used to be, and for someone to have the expertise across all the trades is not possible, I don't think. But secondly, it kind of says that actually, if the clerk of works doesn't see it, you've got away with it. And shouldn't we be in a position where the individual who does the install is responsible for that work?
Yeah. I mean, similar sort of things was said about CDMCs and having a coordinator who could kind of stand aside and have oversight over the progress of a project. I think the idea that if you don't see it, it doesn't really matter isn't the approach to have, and it doesn't really work anymore. I think we've known for a long time that ignorance isn't bliss, and it certainly isn't a defense in court. What you need to show really is ongoing monitoring of safety and risk, and being adaptive in the way in which you as an organization, or you as a senior individual within that organization, is monitoring that. Because you are not going to be able to say, I didn't know. It's actually about what you should have reasonably known. And this approach is and has been developed in other legislation that those in construction are very familiar with, like construction design and management regulations, like the Health and Safety at Work Act, like the fire safety regs. So a lot of them talk about reasonableness, and it's not about what you actually did or did not see, or did not do. So having an approach that suggests, I haven't seen it, I wasn't aware of it, how could I have known? Actually, from a legal point of view, it's about what you should have known. So that kind of approach wouldn't work, and it certainly won't work now with this prescriptive approach in the Building Safety Act.
And if you do see something, there's a duty to report, is there not?
And there's a duty to report if you see a safety risk, and it's explicit within the it's explicit within the Health and Safety at Work Act. It's explicit within the fire safety regulations, and again, the Building Safety Act has adopted a very similar approach.
Great. So can we move on a bit to that? It's rapidly changing. It's developing all at the same time. And, for contractors, this can be very confusing, because then, which bit do I understand? Which bit do I have to follow? And we're seeing I describe it as gaslighting. I'm seeing people say, only my qualification or course counts, and implying that everyone else will be non-compliant and you're going to end up in prison because you're not compliant. How should the industry deal with that from a practical legal standpoint, and how do we respond?
So I have heard claims of this nature. I think when I spoke to you, David, was the first time I heard it described as gaslighting, but I completely understand what you mean. There are people, thankfully not lots of people or organizations, but there are people who are saying their qualification is the one that counts, everyone else is going to be non-compliant. It's a very damaging statement to make, particularly in the current market. And I think everyone has to be clear, there is no one single qualification or course or training provider that has a monopoly on competence under the Building Safety Act. While the Act doesn't prescribe specific qualifications, it does require duty holders to be competent, and it sets out what they mean by that through the reference to skills, knowledge, experience, and behaviours. But how that competence is achieved and evidence isn't mandated. So it's strange that there would be people out there who claim that they are the only ones who can help people achieve compliance. I mean, I could do exactly the same as a lawyer and say, I am the only lawyer, or this is the only law firm that can give you the right advice on building safety compliance. But that's untrue. As much as I'd love to say it, but it's untrue, because the beauty of the law in this country is the fact that we're quite flexible in the way in which we can achieve compliance, and that's deliberately done. If a training provider or a qualification body implies or states that their course is the only one that makes somebody competent, that's more of a commercial claim. It's not necessarily a legal statement or a binding statement. It's a commercial claim. Clients and contractors who accept it and don't critically interrogate that are taking on their own risk. So if they rely on a claim that's made by someone and it later transpires that that individual or that organization were not actually competent, how on earth could a person then rely on the fact, but they said they were competent? What steps did you take to assure yourself that they were the right providers, or they were competent to give you the advice that they've given? So I think the only appropriate response really to claims like that is to ask the provider to cite specific provisions under the Act, because best will in the world, not everybody has read the 260 plus pages of the Act. I have, but that's because it's part of my job. But you want to test, what do they know about the Act? What do they know about the associated regulations? What do they know about BSR guidance to help substantiate that claim? They possibly won't be able to, but you want to test how much do they know. I think more broadly, this industry needs to resist the commercialization of compliance, because it happened. It happened back 3 years ago when the Building Safety Act was first being talked about, and we started to hear about EWS1s, and there were providers out there who were heralding themselves as the only ones who could do EWS1s correctly, and were charging quite a lot of money for that. Thankfully, that has dissipated. But competence verification is something that is a professional responsibility. You shouldn't be taking these claims as carte blanche truth. You need to test that yourself. It's very much similar to the way in which a client appoints a third party. It's not only for the third party to provide proof of competence, it's also for the client to assure themselves of the competence of the third party. So the onus is on both parties to check whether or not certain claims like these are true or not.
So this may be a question that you're not able to answer, but it's about apprenticeships, and there's some proposed changes to specifically the endpoint assessment, where they're sort of going across the board. They're going to sampling, which to many in the industry looks and feels and sounds like a bit like dumbing it down and going for the, and making it an easier thing to do. Does that expose the government themselves to, well, how are you evidencing competence if you're making something which is, more complex or simpler?
I mean, that's a tricky one, and I suppose there is a much more practical answer to this. Looking at this critically, the Act creates this legal expectation of competence, which we've now said several times, is skills, knowledge, behaviour, and experience. Now, all four of those elements have to be rigorously evidenced. The apprenticeship regime is a pipeline for building the next generation of what we hope will be competent practitioners. And if that pipeline is compromised by, I don't know, cost pressures or other factors, the consequences for building safety are not just theoretical, they're real. They're structural, they'll be long term. And my worry is, for the government, that risk is a direct risk. If you're going to be sampling or having a sampling of skills and knowledge rather than the full end-to-end assessment, I don't think competence in a safety critical context like this can be demonstrated by sampling. A structural engineer who can prove competence on some tasks but hasn't been assessed on others hasn't demonstrated competence to the legal standard. They've demonstrated partial competence. And so if you were to apply that to a higher risk building, for example, partial competence in a critical role like that is dangerous. So I think if the government moves ahead. I'm not even sure if these reforms are or have already gone through, but if these are reforms as stated do go through and they reduce the quality of the endpoint assessment, and a graduate of those schemes goes on to then carry out work in a high risk building and then causes harm to the legal standard in that building, the regulatory and political accountability for that failure will and should attach in part to the policy decisions that allowed it. I question whether or not the government will actually be held accountable. I've got lots of stories about the government and whether or not they are being held accountable for various implications and impact from the implementation of this act. But if the act is created to provide duties for individuals and for organizations, but it was the government that created the pipeline, it should be the government that are held accountable if there is an issue with the apprenticeship reforms. I think for training providers, it's a bit more clear cut. The risk is regulatory and it's reputational in nature. If you're providing or endorsing qualifications that don't genuinely verify the competence at the legal standard required under the Act, even if those qualifications comply with the proposed apprenticeship framework, that creates exposure for those very providers, particularly if that misalignment has been later scrutinised. So I just think building safety competence requirements should be non-negotiable, particularly at the apprenticeship level.
Great. Final question. And this is really about if you give it a simple 3 questions a client or a main contractor should be asking of a specialist contractor before they appoint them. What are the 3 things that they would really be checking on?
Okay, so I think first question is, can you show me 2 or 3 comparable projects that you have done where you've performed this specific role, and walk me through the building safety decisions that you've made. I think that's going to test the experience point and the ability for them to articulate professional judgment. Second question, what are the 2 or 3 most significant changes to building safety regulations or technical standards that you've seen in the last couple of years, and how have they changed your practice? So I think that tests whether their knowledge is current, because you'll then have a discussion around the relevant developments to building safety, and see if they're able to translate their learning into affirmative action, not just awareness. And then the third question, I'd want to know how they respond to hazards and risks. So I'd ask the question, if you identified a building safety concern that your client or your lead contractor didn't want to hear, what would you do? And that, I think, is much more of a behavioral question. I'd listen out for their approach to responding to risks that have been identified. You don't want to hear things like vague answers to, we would follow the process. It's a bit less reassuring than a clear account of how they've actually dealt with an escalated concern and what actually happened on the job.
Great, thank you. So I've now got to try very briefly to summarize. So basically, competence, everybody's responsibility. You have to be able to evidence your competence in many ways, and it's not simply having a certificate to prove it. You've got to show your skills, knowledge, experience, and behaviours. Behaviours are the most difficult to evidence, I guess. They are. It's very much about what you do rather than what you say you do, and there's always a big gap between the 2 things, I feel. If you come across gaslighting, you should ask pertinent questions like, tell me exactly why your course is the only one that meets the requirement. And that you should constantly be testing and retesting yourself to ensure that you are A, up to date, and B, able to evidence your competence across the board. Have I missed anything?
I think that's fair. I think, people need to ask themselves, could we, are we comfortable with what we did if we were to be stood in front of a judge in a dock tomorrow? And if the answer is yes, then you can be reassured.
Yeah, as Paul Morrell says, if you're before the judge and they say, why did you choose that? Probably they were cheap is not a good answer.
It's definitely, listen, anything to do with cutting costs or as we say in the legal world, putting profit before safety is never a good look.
Great. Kizzy Augustin of Mishcon de Reya, thank you very much for your time this afternoon. It's much appreciated, and we'll see you again soon.
Thanks, David.